welcome all of you to the second event in the annual Lowndes Human Rights Project Distinguished Speaker Series. I'm Bethany Barrett. I'm a professor of political science and director of the Joseph Lowndes Human Rights Project. And just a few words about the project. The project focuses on several intersectional areas of human rights, this year engaging with the profound effects of global populism, its implications in a heterogeneous polity like the US, and especially its impacts in Chicago. We're very proud to welcome Colleen Connell, Executive Director of the ACLU of Illinois, today. Before I introduce her more fully, I just want to offer a few words of thanks. So first, in a conversation about immigration, I want to just acknowledge that we're on traditional Miami, Illini, and Ho-Chunk territory and thank the original caretakers of this land. We are all actually from immigrant families. Second, I'd like to thank Joe Lowndes, the founder of the Lowndes Human Rights Project and an alumnus of Roosevelt and also of the University of Chicago's School of Social Service Administration. So he's done so much, but I'll keep it brief-ish. One of the founders of the Center on Halsted, former president of the SSA Alumni Board, current president of the CAS board here at Roosevelt, so that's our advisory board for the college. He's also president of the Chicago Art Deco Society and of the International Coalition of Art Deco Societies, and actually one of the co-authors of a forthcoming book from Yale University Press, Art Deco Chicago, Making America Modern. So Joe's generosity and initiative, can you just wave in case anybody doesn't know who you are? Thank you. Joe's generosity and initiative has made possible field experiences here and abroad for 9 generations of Lowndes Project students so far. I also want to thank in the College of Arts and Sciences, Deans Bonnie Gunzenhauser and Julie Rowan, the Director of Development, Erica Mazalewski, as well as my colleagues from the Department of Government, Law, and Justice. Their unfailing support and collegiality is essential to providing these kinds of life-changing opportunities for our students. The Lowndes Human Rights Project is unique in the nation opportunities that it offers students to engage in policy-relevant research and actionable cross-national research. Taking a multi-pronged approach, we investigate and craft responses to a constellation of mutually implicated social justice challenges. This year, as I mentioned, our students are exploring the sources of human rights implications of populism from as many angles as possible. The site of racial violence a century ago, abandoned industrial areas in the southeast part of the city, and from the vantage point of immigrant communities who've made Chicago such a rich and vibrant cultural center. We thus aim to identify the most fruitful avenues for the pursuit of greater justice by learning from key advocates and organizers in the field. This is one of 5 events actually this fall, so we encourage you to join us in future weeks as well as we welcome members next week of the Protection for All movement. We also hear directly from those affected by human and civil rights liberties challenges here in Chicago, and learn from experiences of communities elsewhere with regular travel courses. So we're going to be looking at comparable challenges around populism in the UK this year. We go somewhere to study things comparatively each year. This time we'll be going to look at the trends that led to the Brexit decision in the UK. But why we're all here, obviously, is to hear from the wonderful Ms. Connell here. Ms. Connell joined the ACLU of Illinois in 1984 and has previously served as its Associate Legal Director and Director of the Reproductive Rights Project. Her legal practice has taken her to courts of all levels at both the state and federal justice system. She's argued before the Supreme Court of the US on important matters involving the rights of women to control their own reproductive health. In January of 2001, Colleen became the first woman attorney to lead the ACLU of Illinois. As executive director, Ms. Connell has expanded the organization's legislative and communications programs, its national security and informational privacy docket, its institutional reform litigation, with active cases challenging conditions in state facilities or state-subsidized facilities for the children, the mentally ill, the developmentally disabled, the physically disabled, and people detained at correctional facilities. In recent years, the organization's won major victories to protect racial and ethnic communities from being victims of racial profiling, to limit the authority of police to conduct mass arrests of young people on Chicago streets, to protect reproductive health care, and to bring much needed improvements to Illinois' Child Welfare Agency, the Illinois Mental Health System, and the Cook County Juvenile Detention Center. On a more personal note, I first met Colleen at a panel organized by the Chicago Action Alliance in May. I had just spent several weeks in a remote part of Yellowstone National Park doing field work and was hungry for political engagement. At a time when so many have felt frustrated, angry, and overwhelmed, Colleen was so eloquent, impassioned, but also so poised that one could not help but feel a sense of calm and a restored commitment to a strong and steady perseverance. It was the perfect catalyst to the next chapter in my own political engagement. I have a small token here of my gratitude and esteem, which also nods to Colleen's tremendous contributions to reproductive rights. So you don't have to open it right now, but that's just a little something. I think you'll understand the reference.
Hey, and I get a tote bag with University. Thank you.
You're welcome. So we've structured this afternoon as a conversation. We'll leave plenty of room at the end for questions and comments from the audience, but we also encourage you, especially students, to please ask questions at any point in the conversation. So without further ado, please join me in welcoming Colleen Connell.
Thank you, Bethany.
So I think you're going to start by giving us just a little bit of overview of what the ACLU's priorities are right now. I know it's challenging because there's so much happening on so many fronts.
There are. So we basically bifurcate our agenda onto both a federal and a state level. And on the federal level, our work is pretty obvious, and it's to push back as effectively as we can on President Trump's unlawful and unconstitutional initiatives. And we have, as probably everybody has seen, we have been very active in challenging the travel bans on refugees and lawful permanent residents from predominantly Muslim countries. We filed one of the challenges to the ban on transgender people serving in the military. We have pushed back in our administrative advocacy against efforts by the Department of Education and the Department of Justice to peel back protections on women's rights, on the rights of students who are transgender, on civil rights enforcement, on the Department of Justice's work to really police the country's police departments. And we have continued our affirmative advocacy, but it's much more challenging on one of our centennial goals. The ACLU turns 100 in 2020. And that, one of our most important centennial goals is to reduce by 50% the number of people who are incarcerated in America's prisons and jails, a disproportionate number of whom are people of color. I think we should make no mistake that the criminal justice system has become, quite frankly, the new Jim Crow. It has become, over the last 20-some years, 30-some years, a way of imprisoning, tens of thousands of primarily young men of color. So we are continuing to push forward on that. And one of the other issues that has gained accelerated importance is the importance of the right to vote. Not just pushing back against the planned excesses of the Kobach Commission. The concept of voter fraud in this country is by and large a myth. There is virtually no evidence to support Chris Kobach's claims that millions of people who are undocumented vote in this country. This has quite frankly been rebutted by the voting officials in the 50 states who basically consistently say there isn't a problem. But we're also concerned about the security of our voting apparatus. The Illinois voting apparatus was one of the systems that was penetrated, likely by the Russians during 2016, although the evidence is pretty substantial that no control was exercised over either votes that were cast or the counting of those votes, in part because our election apparatus is so decentralized. It's both a strength and in some ways a weakness, because it's very hard to have sort of effective, instantaneous nationwide reform. So that's basically what we're doing on the federal level. We're, if you like to think of it, we're mostly keeping our fingers in the dike to keep those federal protections as intact as possible. On the state level, we are really, I think, once again singing the praises in some degrees of the founders of our country. The federal system has many strengths, not the least of which is that the federal Constitution is the floor below which protection of rights cannot fall. But it's not necessarily a ceiling. States are free in many instances to provide more protections for fundamental rights than the federal Constitution requires. And the state of Illinois has a much more modern constitution. Our Constitution was ratified in 1970, and unlike the federal Constitution, for example, it has a specific protection for gender equality. And so much of our state litigation work and much of our legislative work has been aimed at expanding those rights, and that is particularly important at a time when those rights are under attack from a federal system. And so just very briefly, we had some very important victories in the Illinois General Assembly this past legislative session, even though it was a long legislative session and it did not look like we were going to get a budget until really, quite frankly, a month after the session had ended and they needed to call a special session. But in the midst of all of that, we secured some very important victories. We passed a law that the governor signed reforming civil asset forfeiture. Civil asset forfeiture is a much abused tool whereby law enforcement can confiscate a person's property, car, cash that you're carrying, even a house, under the claim that that property was used either in the commission of the crime, or that that property was really purchased with the fruits of the crime, meaning, you know, essentially cash or money that was generated from the commission of a crime. We reformed the law to require actually a criminal conviction as a necessary element of the government being able to seize your property. And so it restores what we think is the appropriate constitutional balance to the use of forfeiting property as a way of, you know, enforcing or really extending the criminal justice system. We also had a very important reform of a much abused law that allowed sweep arrests, basically, again, of young men of color, primarily in Chicago and some of the other larger urban areas in Illinois. You could be picked up merely for being in the presence of someone who was a gang member, even if there was no criminal activity that was being engaged in, you know, just if you happen to be standing on a street corner or in front of a 7-Eleven. And so we basically got that part of the law repealed. You have to be actually in the commission, in the act of committing a crime or probable cause. It has to be shown that a crime was committed before you can be arrested. So a big gain that will make a difference in terms of the number of people going into the justice system. We also had a significant victory on the state level on reproductive rights. House Bill 40 did two things. First of all, it extended coverage for comprehensive reproductive health services, including abortions, for women who get their health care coverage through Medicaid, and for state employees who are on state employee insurance plans, which is a big gain for low-income women and for women or dependents who are on state of Illinois insurance. The law also had a second provision, which was basically a repeal of a so-called trigger law. A trigger law is a technique of questionable validity, but in the era of Trump, I think too big a threat to really tolerate. An old Illinois law that predates even me at the ACLU, so it's really old, basically says, in the Illinois abortion law of 1975, it says, we are, in the sections that follow, going to promulgate an entire new abortion law, but in the event that the Supreme Court ever overrules its decision in Roe versus Wade, a 1973 decision which said that the Constitution protects the right of a woman to have an abortion. If the state of Illinois, or if the Supreme Court ever were to overrule that decision, we, the state of Illinois, would go back to the bad old days where it was a crime for a doctor to perform or a woman to have an abortion unless that abortion was necessary to save the woman's life. So a very, very, very small number of abortions, and not even broad enough to encompass pregnancies that were caused by rape or incest or pregnancies that threatened the health of the woman. So those were four big legislative initiatives that either protected or expanded the rights of people here in Illinois in ways that are, quite frankly, safe from some of the worst abuses of the Trump administration. And we also were very significant allies on a couple of other bills that were that were the primary initiatives of our coalition partners. One is called the Trust Act, and it essentially makes Illinois a sanctuary state. And Governor Honor signed that as well, so it was a very significant way of saying the state of Illinois welcomes, particularly undocumented immigrants who were brought here as young people, the colloquially known dreamers. And so that was another really important initiative that we supported. So you can see how we've sort of bifurcate our thinking on this and keep our fingers in the dike on the federal level, push back against abuses, and use our legislative and litigation abilities on a statewide basis to try to push forward with reform here in Illinois.
So much ground being covered and so much ground to cover, right? I wonder if we could talk a little bit about voting for just a moment. So you were mentioning the presidential, voter fraud body that's been put together, which recently there's been some suggestion even from some of the members that it may not meet again because there's so little evidence and for other reasons. But one of the bigger issues, obviously, in terms of working its way through the courts right now is, of course, and I know it was just heard, 10 days ago, less than 10 days ago, is the whole idea of gerrymandering. And so I wonder if you could speak a little bit about kind of the significance of that case and related ones that are working their way through the courts.
Absolutely. So the case that Professor Barrett was referring to is a case that came out of Wisconsin, and it deals with political gerrymandering, and there probably is no other kind of gerrymandering. It's all political gerrymandering, although it sometimes takes a little bit different shape. So much of the gerrymandering litigation and jurisprudence heretofore, but not all of it, has really been gerrymandering that has often been on the basis of race. But race increasingly has been used as a proxy for partisan gerrymandering because many of the people in charge of drawing maps see race, particularly African Americans, as a proxy for Democratic voters. But in Wisconsin, race was not as much of a factor, given the particular demographics of Wisconsin, as was the sheer partisanship of the effort to draw the maps, the state legislative district maps, in a way that favored the Republicans rather than the Democrats. And what was so significant as a matter of fact, and we hope as a matter of law, not because the ACLU is partisan, we're not, but because we feel that the map that was drawn in Wisconsin really is a perversion of any concept of sort of equally weighting the number of voters in each district. And I say that because of really, I think, some groundbreaking demographic work that shows sort of not a new concept, but a newly refined concept of the concept of sort of the efficiency of the gerrymandering or the districting process. So, for example, in Wisconsin, the percentage of voters who voted Republican was 48% of the voters. Yet, because of the way the new district maps were drawn, the Republicans picked up 60 of the 91 or 92 seats in the Wisconsin House. And so you can see, less than half the vote, the number of voters, the percentage of voters, and yet 2/3 of the legislative seats. And the reason that this case is so significant, there's a bunch of reasons, but one of the reasons it's so significant, and one of the reasons that many, not just voting rights advocates, but court watchers are watching this, is because the area of voting rights and districting jurisprudence has been so very complicated and so political. And the Supreme Court has had a number of partisan or political gerrymandering cases in front of it over the last 40 years, and has recognized partisan gerrymandering as a problem, but has come right up to, but not crossed the line of saying this is too much partisan gerrymandering to survive constitutional scrutiny. And there is some anticipation that this may finally be too much. Justice Kennedy, again, is the swing vote. And one of the reasons that the court has hesitated to walk over that line is the court's appropriate, but perhaps too rigid, respect for the political branches of government. And this is, those of you who have had political science classes on that have covered the court will know that in the early 1960s, when the court decided the Baker case and Reynolds versus Sims, those were the first two cases in which the court had actually really accepted and then decided a case that really showed that the district drawing or that the districting process raised constitutional, or in one case, voting rights process. And Baker versus Carr and then Reynolds versus Sims sort of promulgated the well-known lay standard of, one person, one vote, or one man, at that point in time, one vote. And, the court has long struggled with the notion of, how do we basically insert ourselves into what is really a political process with any kind of judicially enforceable standards? Because, we recognize that the legislative branches, the executive branches, are people who are supported by the voters, and ultimately the voters have to be the ones who say enough is enough. But at the back of their head is sort of lurking this concept that sometimes the system gets so out of whack that even when the majority of voters have spoken the other way, their votes are marginalized by virtue of a districting system that's so out of kilter, and maybe the Wisconsin case is finally too much.
One can hope, right?
One can hope,
We're not
yeah.
supposed to have a decision until like February, is that right, or something?
Right,
So.
and the real question is, if it's by February, maybe it's timely enough to capture some of the primaries, but if it's June, maybe it's enough to capture the fall congressional or state legislative districts, but it's going to be a tight time frame for the 2018 elections.
So just while we're on the topic of the court for a moment, I think that, because I'd like to come back to the Trust Act, but I think there's so much to say about that I just want to stay at the federal level for a moment. So I think that in like the day-to-day kind of crisis-oriented coverage that so much of the media is in right now, and what's going on with North Korea and what's the latest tweet, that it's easy to lose sight of areas where there's also really important kind of incursions into rights being made, like reproductive health. And so I was wondering if you could just say a little bit more about kind of where the ACLU is working. I know you talked a little bit about the state level, but kind of like what the front looks like there right now, including not just abortion rights, but also efforts to scale back like contraceptive coverage and the like.
So it looks a lot better on the state level than it does on the federal level, and I'm going to come back to that. On the federal level, it is really grim, one of the things that I'm sure everybody has read about is the decision late last week of the Trump administration to further scale back the contraceptive coverage provision of the Women's Health Amendment to the Affordable Care Act. Do I have enough steps in there? And so sort of a very truncated history of that contraceptive coverage provision. When the Affordable Care Act was being considered by Congress, the Obama administration was working through the National Institute of Health, created a separate commission to really look at the issue of women's health care and insurance coverage, because the facts at the time that the Affordable Care Act was being considered, were quite shocking, and particularly the fact that women, as a general rule, paid more than 40% greater out-of-pocket costs every year to obtain health care did men in the relevant age, demographic, and risk groups. And that seemed to be sort of true across the board. And there's no way to gloss over what was the reality, which is that the norm for health care was a male norm. And it's, it's just, what the reality is. I mean, I am hard pressed to identify any insurance plan, pre-Affordable Care Act, that, was made broadly available that exempted out coverage for conditions that were uniquely male, you know, prostate issues, prostate cancer, testicular cancer, anything that was uniquely male, or even anything in which the male risk groups were, you know, much higher than women. And we haven't even tackled the fact that, you know, still to this day, most of the testing, most of the clinical trials use male subjects rather than female subjects, even when the oft-given norm is, well, we don't want to use women in clinical trials because we don't want to risk their reproductive capacities. And that's a very valid concern, but it's also myopic because some of the clinical trials would affect the reproductive capacities of men as well. You know, I could go on, but I won't because I know this is not a healthcare seminar, but I will leave you with sort of the one thing before I go back to contraceptives. I mean, you know, one of the things that also came to light was that for many years, the joint replacements, knee and hip replacement, that you know, have really become a very important part of American healthcare as people age and live longer than they used to. You know, that until relatively recently, the replacement joints were sized, wait for it, for men, not for women. Even though you know, women had you know, comparatively as many replacements as men did. So it was a system that wasn't working well for more than half of the population. So kudos to the Obama administration, kudos for the National Administration of Health for basically saying, we're going to look at this as we're tackling how we cover healthcare. And so in the course of tackling it, wait for it, one of the areas in which you know, out-of-pocket costs were greatest and coverage was almost non-existent was in the area of contraceptive coverage. Women just, for decades, have paid out of pocket for oral contraceptives, the birth control pill, for IUDs, for LARCs, long-acting reversible contraceptives, Norplant, commonly known. And so one of the most significant recommendations of the Commission on Women's Health was that that insurance plans should cover the cost of contraceptives as sort of a no-pay part of, you know, your health insurance, or a limited copay, you know, like every other medicine. So the Obama administration anticipated that there would be objection by some religions who have a religious objection to either contraception, I'm going to put artificial in air quotes, but artificial methods of contraception. The Catholic Church has long considered artificial contraceptives, which it defines as anything that doesn't involve the rhythm method of contraception. So think condoms, think birth control pills, think IUDs, think Norplant. All of those are considered artificial methods of contraception, and they are considered, you know, contrary to Catholic religious belief. And so the Obama administration created a religious exemption in which it basically exempted religious organizations like churches, like religious orders, and then established an accommodation for religiously affiliated employers. The First Amendment law in this area is really complicated, so I'm just going to give you sort of an introductory course, and I'll come back if I'm invited for a long discussion of First Amendment law. But basically the law for decades has appropriately distinguished between churches and say basically if it's, you know, what your clergy can do, whether you have to have women clergy, whether you can have married clergy, that's a matter of religious doctrine, and the government has no place in that. We're not going to tell you that, you, the Catholic Church, have to let your priests marry. That's inserting government into the free exercise of religion. We think it's violative of the First Amendment. Hands off. That's totally the right spin on it. But as the distance between the actual practice of the religion, the theological part of the religion, the church itself, the religious services, the priests, the nuns, the monks, as you get further away from that, and as you become, for example, a religiously affiliated university, you're more secular. And the law has long required that in the secular operations of a religiously affiliated or university or employer, you have to comply with generally accepted, universally applicable law, like the withholding from people's wages and salaries. You've got to comply with the withholding taxes. You've got to pay Social Security. If you're building a building to house your students, you can't be in violation of the building codes just because you're a religious organization. All that makes perfect. You don't have to be a lawyer to say, oh, that makes a lot of sense. There's a compelling governmental interest, which is the legal standard, in not having students put their life at risk because they're going into a building that's poorly constructed. And so back to the contraceptive provision, the Obama administration created a carve-out for religious organizations and a way of accommodating religious employers. But we get to the Hobby Lobby litigation 3 years ago, and a number of corporations that were secular corporations, the Hobby Lobby Corporation being one, and the Conestoga, and yes, it is the old Conestoga company that manufactured the covered wagons that went out west. It now makes, I think, sort of vehicle parts, truck beds and stuff like that. Challenged the contraceptive coverage provision, saying that it was contrary to the religious beliefs of these closely held, meaning family-owned corporations. Supreme Court held that the contraceptive coverage provision violated the Religious Freedom Restoration Act, RFRA for short, but didn't reach the first, whether it violated the Free Exercise Clause of the First Amendment. So fast forward, we now have a number of religious organizations, like Little Sisters of the Poor, saying that the accommodation that's provided, that basically you say, I'm a religious organization, I don't want to provide contraception, so therefore the federal government has to take care of it. Just filling out that one-page federal form is too burdensome on their free exercise of religion, so the accommodation itself violates their religious liberty. Went up to the Supreme Court. The Supreme Court deadlocked 4-4. It was before Judge Gorsuch was either nominated or confirmed. It was during the last year of the Obama administration. So the Supreme Court sent it back down for more briefings in the federal court. So what the Trump administration did was expand even beyond religious institutions this accommodation and says basically any employer who has religious objections to contraceptives doesn't have to provide contraceptive coverage in its insurance package. And there's so much wrong with that. I almost don't know where to start the analysis. And I mean, the first thing that's wrong with it is, it's really, quite frankly, and the Supreme Court got it wrong in Hobby Lobby also, it's sort of a violation of fundamental concepts of corporate law. The whole notion of establishing a corporation is that you separate the ownership from the liability. And so, if a corporation has bills of $100 million, but only assets of $90 million, the creditors can only get the $90 million in assets. They can't go against the private wealth or assets of the people who own stock or shares of the corporation. And this is a concept, believe it or not, that not only predates the United States Constitution of 1787, it predates the Magna Carta, 1215. It goes back to Roman times, and ironically, one of the first corporations to get incorporated under Roman law was, wait for it, anybody want to make a guess? The Catholic Church. And so they got it wrong in corporate law, but they also got it wrong in sort of basic concepts of American Constitution law, because this old concept of your right stops at my nose is really a very comprehensive doctrine that covers speech, that covers religion, that covers assembly. It's basically, you can think, you can believe, you can really say pretty much whatever you want, and government can't restrain it unless your action violates the right of someone else. And so you can believe whatever you believe. You can believe in not using birth control. You can believe in not having an abortion. You can believe in, fasting during, Ramadan or during Lent. But what you can't do, and what historically the United States government has done, is impose those religious beliefs on everybody else. So as everybody knows, even though some schools are closed for Good Friday, even though some government offices may be closed for Good Friday, we don't require everybody in the United States to go to Mass on Good Friday, or to not eat meat on during Lent, or fill in the blank, and rightly so, because this is a very diverse, religiously diverse country as well as everything else. And so to say that employers could impose their own religious beliefs on their employees is just at odds with corporate law, with First Amendment law, and I think, quite frankly, with the whole concept of the freedom of religion, because the freedom of religion at its most fundamental notion, and from this I borrow from one of our board members who's an ordained minister, is the voluntary acceptance by an individual of God's grace. And if you force that belief, or you try to force that belief on another individual, that makes a mockery out of religion itself, which again, is the individual asking for and receiving, God's grace or God's forgiveness or Allah's grace or forgiveness. And it just really, quite frankly, makes a perversion of any concept of freedom of religion. And so it's really, I think, flawed. And and it I think is so obviously an insult, to women, because in this country, women still bear the primary responsibility, for contraception, for contracepting, and the lie that came out of the Trump administration that this won't affect 99% of American women is absolutely false. 98% of American women of all religions use artificial birth control at some point during their reproductive life. It affects all of us, and it affects all of us in this room who aren't women but are sexually active, because pregnancy is something that that happens only, to state the obvious, between the union of a sperm and an ova. And it affects all of us, but it affects women more directly and more immediately. And once we're on this slippery slope of, okay, so what about people who believe that vaccination is either contrary to their religion, and there are some, or isn't safe, a concept that's been completely rebutted, including by the medical journal that published the anti-vaccination article. Would we allow insurers not to cover the immunization costs of our children? And what about those of us who might be, Jehovah's Witnesses and who believe that blood transfusions transgress the biblical prohibition against eating blood? Would we allow our employer to not cover the cost of a blood transfusion for a child who's a hemophiliac, or for somebody who is grievously injured in a car accident, or in a mass shooting that occurs on average of every day in this country, with mass shooting defined as more than 4 people shot in a single incident. You can see where that slippery slope really leads. And so I think that is a really scary decision, not just because of the practical consequences of it, but because of the lies that accompanied the rollout of this provision. On the state level, I'm going to transgress and say that it's I wish to say one more thing. The ACLU has already filed a lawsuit challenging this. We think that it was not done consistent with the Administrative Procedure Act. We think it raises real questions about the scope of executive authority in contravention of a specific law of Congress, because the Women's Health Amendment is part of the Affordable Care Act. And so I think that it's going to be tied up in litigation. Let's hear it for the courts. On a state level, we have done actually, I think, I'm going to say a fortuitous job of protecting access to contraceptives as part of a more comprehensive concept of what healthcare should really provide, in part because of the resistance that we've encountered with insurers covering contraception. So a number of years ago, like 4 years ago, the ACLU, working with a number of other coalition partners, including Planned Parenthood, EverThrive, Public Health Association, got the Illinois General Assembly to pass a contraceptive equity law that requires broader insurance coverage of contraception, even than the Affordable Care Act did. We didn't know how important it was going to be at the time that we actually got it passed. This is again where I want to say is a really important lesson that I hope all of you integrate to your very core, and that is the issue of do not despair, even though the temptation sometimes is overwhelming, because there is so much that we can do, each and every one of us, on a daily basis, in the city of Chicago, in the county of Cook, and in the state of Illinois, to protect fundamental rights, and to reaffirm our humanitarian communities, to protect the rights of all of us. And I think it's challenging, not just because of how depressing the pronouncements are that come out of the Trump presidency, but because, it's not original to me, because he is really truly the chaos president. And I think some of it is deliberately obstructing our view of sort of the other things that are happening. But I think sometimes it's also just because of the very nature of who he is. I mean, he is not a serious, disciplined thinker who actually, from my perspective, has a game plan of, okay, well, today we're going to really think about what's wrong with fill in the blank, healthcare, immigration, policing, and then, you know, studies, and he's a very responsive. I don't mean that in a positive way. He responds to what he sees as an insult or an affront or something that he thinks will rile up his base. And you know, the current controversy over NFL players kneeling or not kneeling for the national anthem, I mean, again, distorting the reason for the protest, which is the level of police violence directed at particularly young men of color. It had nothing to do with the military, and yet Trump and now Pence are saying, well, we won't be complicitous in disrespecting our military. This from a man who had 5 deferrals and who described as his own personal Vietnam avoiding sexually transmitted diseases. And I have to say, I really take this personally because I have a son who's an officer in the Marine Corps. And you know, the notion you know, that this man is distorting these protests and the reason for these protests, and you know, taking refuge, you know, I think illegitimately behind the flag is disgusting, and there's no other word for it. But I digressed and diverted myself, so I understand the temptation more than I should. But I think that my recommendation to everybody is pick an issue or two that you feel most strongly about, or that you feel like you can have the most impact on, and devote the part of your life that you can devote to informed advocacy and action to those 1, 2, 3, or 4 issues. And then be a good fellow traveler or good ally on the rest of the issues that are also really important, but no one and no one organization has the bandwidth to cover. So, we practice what I'm preaching at the ACLU. We have, you know, we are not, as I'm sure is obvious to everybody, we are not a single issue organization. We don't just do reproductive rights. We don't just do LGBT rights. But we have, I want to say, probably 10 core areas, which are a lot, but by no means comprehensive of all the issues that are under attack by the Trump administration. And so we pick our battles. We continue to pour resources in the areas where we are strong, where we have expertise, and we lend that expertise to our allies if they need it, because they don't have that expertise. And so the most practical example I can give you is in the immigration area. We don't do here in Chicago a lot of direct representation of people who have immigration issues or challenges. We have lots of coalition partners who do great direct services. But what we do, and they by and large don't, are big federal impact class actions. So the deal that we've informally cut with them is, if we see another travel ban, which the ACLU challenged in multiple jurisdictions across the country, or if we see the Immigrations and Customs Enforcement coming in and enforce and basically arresting people without warrants, or asking local law enforcement to put an immigration hold on detainees but without a warrant, then the ACLU will come in as a litigation partner and use our decades of federal litigation prowess and experience to file that class action lawsuit, in which you will be a partner because you know immigration law, but we know federal procedure and federal jurisdiction law. And so I urge each of you, to think about cutting those same informal deals with friends and allies. So maybe you're a reproductive rights warrior, or maybe you're an immigration warrior, and you're going to be writing to your member of Congress or your U.S. Senator or marching in the street on those issues. And you say, I can't know everything, I don't have the personal experience on these other issues, but when your friend says, hey, I'm marching in the Women's March, or I'm marching to support the Dreamers, be a good ally and say, you know what, I don't know everything about this issue, I want to learn more, but I trust you, I believe in you, and yes, I'm going to march with you, because it's really, really important for us to continually reinforce the notion that there are more of us than there are of them, and there are. And we aren't going to get through this next 3 years and 4 months any other way without constantly reminding ourselves of this. And it's so important in more than just the feel-good motion. I do believe, and I believe this firmly with all of my heart, that the Supreme Court not only follows the election results, as the pundits say, but it reads the newspapers and it follows the news developments on the internet. And when they see thousands of people turn out, like thousands of people turned out overnight for those immigration marches at the airport right after the travel ban, that strengthened the resolve of the federal courts to do the right thing and to stretch a little bit. And so this is sort of a secret of lawyering that I'm gonna, my 30-minute or 30-second commercial for why I hope those of you who are undergrads and are thinking about law school, think about it as a wonderful, honorable, helping profession. Our courts are courts of law and courts of equity. We have a combined federal court system. It's, I think one of the real beauties of our federal court system. And so, yes, courts have to follow the law. And so when the law, the written law, whether it's in the Constitution or the statutes, say, Congress shall make no law limiting the free exercise of religion or the establishment thereof. Okay, that means, Congress will you can't make a law that says you can't be a Catholic or you can't be a Muslim. But there's this concept of equity and doing justice. And we need our courts to stretch to do justice. And when they see thousands or tens of thousands or sometimes hundreds of thousands, and in the case of the Women's March, millions of Americans across the country turn out in the street. Judges see that and they pay attention, and they know that Americans at their essence just incorporate in our national DNA this concept of fairness and justice. And it's our job, day in and day out, to live those concepts. If you're not a lawyer, it doesn't matter. If you're not if you're not an activist in your day job, that doesn't matter. But we all have that obligation, and it's easy and it's fun. So that's my commercial for not just going to law school, but also for activism. And there's a lot that we can do, and you don't have to be an expert on every issue.
That's extremely just encouraging and kind of energizing too, because it does, something that I talk about with students all the time is the way that it can feel overwhelming, right? The way that it can be hard to be experts on everything, and that it's important to know there's ways forward that are productive, that are doable.
Right.
Actually, one of the things that Joe and I kind of set out to do when we first started the project was to find places that there's an ability to have an impact in sort of a near term also, so that we can kind of remind ourselves that we have that.
Right, and we do. And I am really going to say, from the perspective of in some ways an insider to the political culture given our legislative work. And the ACLU is very fortunate to have on our board a couple of members of the Illinois General Assembly. Don't think that just because we live in a state that is thought about as blue and progressive, don't think that, again, there isn't anything that we can't do. There is, and I've given you those examples of how we can expand rights, but it's really, really important, and now you're gonna think, oh my God, it's just like being at home. My mother says, remember your manners, but yes, remember your manners. It really matters to our legislators, to our mayors, to our governors, to say thank you when they do the right thing. Because they hear from the other side when they do the right thing and do the courageous thing, and they're getting yelled at all the time. And just because I want to just underscore the concept that the ACLU is truly nonpartisan and we work on both sides of the issue, and that's extremely important for all of us to hear, because it is so hard, and I'm going to say this personally, it is so hard not to demonize the Republicans given who's in the Oval Office, and the fact that so many Republicans have I think, not just swallowed their pride, but they're also their integrity. To remind ourselves, and I'm speaking to myself, that you know, that is not the whole of the Republican Party. And if you haven't sent Governor Rauner an email or called his office to thank him for signing the Civil Asset Forfeiture Reform Bill, the Gang Crime Reform Bill, House Bill 40 on abortion rights, or the bill that allows people to change their gender marker on their birth certificate without undergoing surgery. Please do so, because he is getting beat, and the Trust Act. I know that you want to go back to that, but he is getting beat up by members of his own party for doing the right thing by signing each of these really important pieces of legislation. And there is something wrong when the governor of the state is getting beat up for putting women's health first. He says, I'm going to sign this House Bill 40 because I have spent the last 4 weeks traveling across the state of Illinois, talking to women who've had abortions, talking to public health advocates, talking to doctors. And you know, I think that women ought to be able to have the health care that they need, they decide they need. That's the right thing to do. And the fact that he's getting beat up, you know, for informing himself and changing his position is wrong. You know, and this notion that people can't be informed and then change their mind because the evidence or the facts have persuaded them that their earlier position was wrong or unsustainable is a very dangerous position for our entire society. We cannot, we can't afford to make decisions that are fact-free. I mean, there's no other way to say it, it's stupid.
You've given us so much to think about. I'd like to really open this up to other folks to either push harder on things that we've already covered, or to ask about things that were maybe discussed briefly in that beginning salvo that we haven't returned to yet. Provost Becker.
About the RFRA, what is the shorthand for the
Religious Freedom Restoration Act.
Thank you. I'm not a lawyer. However, I came across something in the course of doing accreditation for a religious school in the South that I thought could be a solution. The school had, you know, dance policy, it had a dress policy, you know, marriage policy, fine. But I had to evaluate whether it was teaching science and whether there was academic freedom. And of course, the examples that they gave for both of these were much more limited than I had ever experienced before. And I went through all the materials from the Southern Association of Colleges. And there's a clause that says, if you profess the faith condition of employment, that then it's all right for you to be under this more circumscribed notion of, let's say, academic freedom. And that seems to me, I'm sure you'll come up with the reasons why not, but if somebody joins the Mennonites and agrees that is willing to profess as a condition of employment, then okay, maybe you can set up some of these religious parameters. But if you're talking about a large hospital like St. Joseph's, which is Catholic, I mean, not everybody at St. Joseph's is going to profess the faith, and therefore you cannot impose upon them religious strictures.
So, Provost Baker, you've raised a really important question, and there's actually two parts of this I'd like to answer. And I'm going to give Professor Barrett the opportunity to tell me when I've gone too long on this, and we'll continue the conversation afterwards. But I want to first deal with the academic situation and then deal with the healthcare situation separately. So on the academic one, I think that provision, the clause that you identified is appropriate, but only for the religious studies provision of the institution. There's a relatively recent Supreme Court case, the Hosanna Tabor case, in which a religiously affiliated school, it was I think grade school through high school, basically terminated a professor because she was out on medical leave. She came back and they discharged her. She sued and basically that they were in violation of the Family Medical Leave Act or something like that. And the school came back and said, you can't sue because a provision of your employment contract said you have to go through arbitration or something to that effect, because our religious order is, basically elevates, accommodation as opposed to litigation. So the Supreme Court ultimately ruled in favor of the employer because they said that the teacher in question was essentially a liturgical employee, because part of her religious duties, or part of her academic duties, were teaching a religion class, and she had to escort her class to the religion class every day, and then one day a week she had to teach religious classes. The court suggested that exemption really only could cover employees that had religious obligations under the concept that I articulated earlier, that when we're dealing with positions that involve the transmission of religious doctrine, then the church has to have complete authority over it. But that in the more secular functions of something, like if you're holding yourself out to be a full-range academic college or university that has an accredited science program, you can't have it both ways. You cannot impose your sort of religious beliefs on the on the secular parts of the curriculum, or those employees who are teaching in that area. And it's something that is, I think, a really important separation, in part because of the history of this country in which religion has been used horribly and recently to discriminate not just against women seeking reproductive health care, not just against gays and lesbians, but think back to the, as recently as the 1980s, and Bob Jones University, which is a Southern university, risked losing its 501c3 tax-exempt status because of its policy on racial integration. And so as Bob Jones University was originally chartered and started, it forbid, I think initially it did not allow students of color to be admitted. Then students of color were admitted, but there was an absolute prohibition against mixed race, fraternization, dating, marriage, you name it, anything like that. And they were at risk of losing their tax-exempt status because they were in violation of Title VI and probably Title VI of the Civil Rights Act of '64. And Bob Jones University claimed a religious justification for its segregative policies. And went all the way up to the Supreme Court, and the Supreme Court rejected that use of religion as a justification for discrimination sufficient to keep its tax-exempt status. And just again for the historical record, in 1967, when the Supreme Court decided Loving versus Virginia, which struck down Virginia's law banning mixed-race marriages, a number of religious entities and a number of states submitted amicus briefs claiming a religious justification for the anti-miscegenation laws. And when you look back even further to the legal challenges to the original civil rights laws that were passed in the 1880s, many of the religious organizations used religion as a justification for their discriminatory policies. So suffice it to say, I'm very uncomfortable on legal grounds, on constitutional grounds, on Civil Rights Act of '64 grounds, along with many state human rights and civil rights laws with that exemption, even though I and the ACLU are very supportive of the concept of religious liberty. But I think it's hard to improve on, render unto Caesar that which is Caesar's, render unto God that which is God's. And, many of the strongest, both First Amendment advocates within the ACLU also were people of strong religious conviction who argued not only the constitutional arguments I just urged, but in their own parishes and congregation strongly argued against the church lobbying for, asking for tax credits or tuition credits or government support for religious schools because of their concern that once you began accepting government money, you need to play by government rules, and that you risked corrupting your own religion if the religious functions now had to comply with a range of state laws that complied with constitutional norms that again recognize the theological diversity of this country. The religious refusals on hospitals and health care is really complicated, and I'll probably say we should talk about it after class or at a further section. Suffice it to say that's an issue that we are litigating and that we have sought legislation on. The Catholic hospitals, and I'm going to say I'm a lapsed Catholic, so I hope you will give me a little more latitude in what I say and not think that I am an anti-Catholic who wants to ban Catholicism or anything like this. But I think that we have a real problem in this country in that two out of every six, at a minimum, 2 out of 6 hospital beds in this country is a Catholic hospital bed, controlled by a Catholic hospital. And although Catholic hospitals do not limit the people they hire, doctors, nurses, techs, support staff, to people of the Catholic faith, nor do they refuse to serve people who aren't Catholic. Every Catholic institution in this country, and some Catholic institutions some institutions that used to be owned by the Catholic Church but no longer are owned by the Catholic Church or any of its healthcare subsidiaries, subscribe to, are forced to comply with the ethical and religious directives, ERDs is our acronym, for short, of a Catholic healthcare provider. And these are directives that are reviewed by a consortium of Catholic bishops and cardinals, and they're quite restrictive, and they impose Catholic doctrine on the provision of medical care in ways that I think are unconstitutional, inhumane, and at bottom in violation of the very concept of informed consent, in which the underlying contractual relationship between a healthcare provider and a patient is that the healthcare provider has to act in the patient's best interest and has to provide the patient with all of the information that is pertinent to that patient's condition, prognosis, and diagnosis, and that the ultimate decision about what healthcare option or options to pursue is the patient's, and that it is that understanding and that contractual relationship that really allows a physician to touch the patient in the kind of intimate ways that are requisite for a medical examination, and that otherwise would be considered a prosecutable assault or battery. And where this strikes most heavily, of course, is in women's reproductive health care. And there are legions of stories and a number of lawsuits in which women who have been miscarrying a wanted pregnancy at a point far before the child is, or the fetus is viable, by which I mean capable of surviving outside the uterus, even with all the artificial life support that a modern NICU, a neonatal intensive care unit, can provide, is denied care, or care is delayed because terminating that pregnancy, evacuating the uterus immediately, is the standard of care that every professional medical society in the country would agree. Because the longer you delay evacuating the uterus, the greater the woman's risk of infection and really, quite frankly, threats not only to her future reproductive capacity, but her health and ultimately her life. And Catholic hospitals will not, by and large, provide that information, and they will not provide that care. And the fact that they won't provide the information, I think, is malpractice. And I can live with them not providing that care, except in an emergency. If they say, here's where else you can go. Because I do think it raises serious constitutional problems for the law to force a devout Catholic to perform an abortion if he or she is morally opposed to it, religiously opposed to it. And I would absolutely defend that doctor's right to not perform that abortion. but I don't think that you can impose your personal religious views on another human being at risk to her own health and life. And in the case of somebody who is an observant a Jew, their religious obligation is to the contrary of the Catholic one. A pregnant Jewish woman whose health or life is threatened by continuing the pregnancy is under a religious obligation, if she's observant, to terminate that pregnancy and to protect her own health and life. And so just the abbreviated thing, the ACLU has been involved in litigation in this. Usually it ends in a settlement. We've also changed a state law here, which is the broadest right of religious refusal that allowed doctors and hospitals to even refuse to provide information. We changed the law so they're required to provide information about your medical condition and to provide the names of other healthcare providers where you are likely to be able to get that care, which is not a referral. That law is being challenged right now by an anti-abortion group and a crisis pregnancy group that does not want to provide the information to their crisis pregnancy patients about their full options. So this is where I do feel like perhaps my early catechism education and the discussions of the Council of Nicaea were not totally to waste, although I'm quite sure that the lovely sisters who taught me that didn't think I'd be putting it to use as an abortion rights advocate.
So we've only got about 2 more minutes, so it would be great to get in, like maybe I could take like a couple of questions and you could answer them together. If there's any way to do that, maybe. Dan.
So time off when you were talking about the ACLU being very bipartisan and not speaking directly liberal, conservative, whatever. I read recently about some controversy within the ACLU people, some lawyers saying I don't feel comfortable defending First Amendment for the KKK in the Charlottesville. Others saying that's the core values of the ACLU. And I just was wondering if you could address that kind of in the light of the bipartisanship you were addressing.
Mm-hmm. Is there another question that's also kind of like nice and succinct like that? Could take at the same time? All right.
So really good question, Dan. So I would say that our core value is protecting the Constitution and the Bill of Rights, and that the uncomfortable part of that core value is oftentimes protecting speech that we hate because it is at odds with other constitutional values that we also advocate and zealously protect. In the case that's been most recently in the news, it's the case involving the ACLU's representation of neo-Nazi white supremacists in the right to march in Charlottesville, and the conflict that that poses with our advocacy for voting rights, racial justice, criminal justice reform, you name it. Just sort of, if you were to sort of weigh the scales of where we as an organization have the most resources currently invested, it's in those other areas and not speech, because of all of our advocacy heretofore, including a very important case that came out of Illinois when we defended the rights of the Nazis to march in Skokie. And it's because of the ACLU's advocacy that, as one of my board members said, free speech in America means something that it means nowhere else in the world. And it really means the right to say, to really criticize your government and those in power. Because at the end of the day, the fundamental value that the ACLU is protecting in our First Amendment advocacy is against government restriction. And the board members who articulated the position that I just articulated in a recent board meeting, have reason to know, because they've experienced firsthand what life is like in countries that don't have this kind of constitutional protection for freedom of speech and an advocacy culture that really has put meat on the bones of that constitutional concept. One of my board members is an Iranian refugee whose parents fled under the Ayatollah. The other is a Chilean refugee whose father was tortured under the Pinochet regime for, wait for it, being critical of the government. My board member, who's an Iranian refugee's book about the importance of human freedoms has been banned in Iran because it criticizes what the Ayatollahs have done to concepts of, freedom of speech, gender equality, freedom of religion. And so it's, it's a really, really important issue, and I say that fully cognizant of the pain that our First Amendment advocacy has caused and currently causes. I mean, and it's pain for our coalition partners, it's pain for our staff who work on racial justice issues, it's pain for our staff who are people of color. And it's always been painful because the legal director of the ACLU of Illinois who litigated the Skokie case was himself the grandchild of Holocaust survivors. His parents were basically ostracized in their Chicago synagogue when David took the case. His marriage broke up over the strain of, what it meant for somebody who was observant and Jewish, to defend the right of freedom of speech that we hated by a group who, quite frankly, has as one of its core principles the obliteration of people who are Jewish. I think that it's important to acknowledge that pain, and I think it's important to acknowledge that, at the end of the day, these are really still important principles to fight for, in part because the First Amendment hasn't always looked this way. The founding fathers of the ACLU and mothers formed the ACLU in part because then Attorney General Palmer was arresting and prosecuting, wait for it, immigrants and they were Russian Jewish immigrants predominantly, for speaking out about socialism and the merits of socialism. And it was sort of our first Red Scare in this country, and they were punished for what they were saying. And most of our ACLU advocacy, not the highest profile, but most of our ACLU First Amendment advocacy has been on behalf of groups that have historically been marginalized in this country. African Americans, immigrants, labor union organizers, think Cesar Chavez, and farm workers, women, think the suffragettes, think abortion rights marchers in the days before Roe versus Wade. It's been politically unpopular ideas. The fact that I think it's not a stretch to say that that white supremacy is unfortunately politically popular by some in the Trump White House, including the occupant of the Oval Office himself, does not mean that those of us who aren't white supremacists can think that our free speech rights are safe, because the Department of Justice, as everybody has recently probably noted, is now going after some of the Black Lives Matter groups as sort of a racial terrorism organization. And talk about making my blood boil. I mean, we're going to be, of course, defending, as we should, the rights of Black Lives Matter and other racial justice advocates, to march in the street and to be able to say, police shootings, which disproportionately are targeted at people of color, are hugely problematic, and they should be actionable, and people should march in the streets and have the right to march in the streets, to ask for better policing and more accountable policing, and an end to the kind of police violence that's historically been directed at communities of color. So another long, complicated, I'm incapable of giving yes or no answers, which is why nobody ever would want to depose me in a deposition. But it's a really hard issue, and I think it's important that we acknowledge the pain. And I don't mean that in a trite way of suck it up. It's painful, and it's what it is.
But I think that overwhelmingly the message that you've given us this evening has been one of hope, one of potential for action, and one of being strategic and prioritizing.
Yes.
And that is incredibly empowering.
Yes.
And we can't thank you enough.
And
so
thanks
much
for being here
doing
and staying. So I really appreciate it. So.